Again, I'd just like to thank Eames Solicitors and Stubbs for asking me to come along today. I'm conscious that I'm in front of your coffee. You don't want an English solicitor blabbering on for too long. I also saved you the having to look at me twice, because I dislike my photograph even more. Aidan asked me really just to talk in brief about the different procedures in England. We're talking about England and Wales. Being married to a Scot, I'm allowed to say that the Scots, certainly from a legal perspective, are very much on their own in this. The three statutory procedures in England and Wales. Firstly, bankruptcy, very simple process. Debtors, principally, as you'll see from the statistics, make themselves bankrupt as opposed to creditors. A creditor can do it. It's a more drawn-out process, more involved with the court. But literally, it is fill a form in, fill a statement of affairs in, pay your fee, get given a date to turn up at court, which can be anything for 6 weeks, and you're bankrupt. It's as straightforward as that. It becomes a little bit more complicated when we talk about the cross-border insolvencies. But as the speaker's already mentioned, discharge automatic after 12 months. It's worth noting actually that that's the maximum period. You can actually be discharged early, and there are people who've been discharged from bankruptcy within a 6-month period. And discharge just means release from obligations from debts. It doesn't mean any assets that were in the estate, they can still be realised, but you must, the trustee in bankruptcy or the official receiver, if they're the trustee, must get the income, have an agreement or an income payment order before the bankrupt gets discharged. And really, I'm going to try and dispel some of the myths. There's quite a lot of, go to England, it's a nice, easy ride for you. I'm afraid there's quite a few sophisticated trustees and bankruptcies out there, and you'll see from the statistics there's quite a large number of them. So if you can, even though you get discharged from bankruptcy, again, your discharge can be suspended. That can be for an indefinite period. And you can still get your discharge from your bankruptcy, but still be subjected to the restrictions for bankruptcy for any period from anything from 2 to 15 years. And this was the sort of the counterbalance. We've already talked about the process where there was a 3-year discharge period in England, and then it was reduced down to 1. So the counterbalance was they introduced something called bankruptcy restriction orders or bankruptcy restriction undertakings, whereby you could be subjected to the process, the downside of bankruptcy for a longer period of time, effectively for the rogues. The alternative to bankruptcy, if you don't want it, is an individual voluntary arrangement. I won't spend a lot of time on it, but it's very much about a contract between you and your creditors. You go to your creditors and say, I'm going to pay X amount a month, I'm going to realise these assets, and your creditors vote. Your creditors have got to 75% of your creditors have got to vote in favour of it. And if you do what it says on the tin, then you come out at the other end. Typically they last 5 years, but they could be any period of time. It's completely up to you. The relatively new procedure that was brought in was a debt relief order, and this is very much the low end of the scale. It was brought in 2009, and it's for debtors who've got less than £15,000 of unsecured liabilities. They have less than £300 worth of assets, and they have less than £50 per month surplus income. And very much, I have to say, much to everybody's surprise really, I don't think most people thought that would really take off. So trying to put into some context, I'm not going to read the statute, you can all read what it is, but that's to give you a sort of context compared to what you're looking at in Ireland. And actually, personal insolvencies in England and Wales, as you can see, is actually falling, particularly the bankruptcy petitions. And as I say, the vast majority of bankruptcy petitions in England and Wales are petitions presented by their own debtors. But rather startlingly, even with those relatively low thresholds for the debt relief orders, there still was 31,000 debt relief orders in 2012. And I put this slide on really just to give you an indication to look at the spikes. I mean, you can quite easily see the spikes in terms of sort of 1994, the first recession. You can see a spike up and down. But the next big spike is 2004, and that coincides with the introduction of the 1-year discharge from bankruptcy, and they go up and up and up, and then now slowly coming back down again. I think you'll probably be more familiar with most of these people than I am, but I mean, it's not a question and answer. You can choose who you like. But I was going to call the slide the good, the bad, and the ugly, but Shane Phelan obviously got the ugly look. But it really gives you an idea of, it's not just, we get a lot of Germans as well, and bankruptcy tourism as a concept and in the courts is definitely much more talked about now within the judiciary. The likes of Mr. Fleming there and Mr. Green, they were the earlier bankruptcy tourists, so to speak. Both have been discharged from their bankruptcy, whereas others, and the more notable ones, Sean Quinn, was the first time I'd actually ever thought about it. Why, if you were going to do a bankruptcy tourism, why not go to Northern Ireland to do it? Surely you can just go up and over the border whenever you like. But he's a classic example of how not to do it, really. And even being in England and Wales and living there all the time didn't really help Brian and Mary O'Donnell. So where are we in terms of this? So the trend really is in terms of one single set of insolvency proceedings, one main proceeding. And the main proceedings, you know, I'll go on to in a moment what the definition of a main proceeding is. But really, because of the EC regulation, it gives an opportunity to people to move to other jurisdictions and open up insolvency proceedings in that jurisdiction, particularly on a personal basis, even if all of their creditors and most of their assets are in another jurisdiction. And it's important to note that if it's done correctly and they open up as main proceedings, then particularly in this case we're talking about the Irish context, but it could be any nation, then if it's done correctly and the main proceedings are there and open, then the discharge from the bankruptcy will affect all of the Irish bankruptcy debts as well. So what's the threshold if you're looking at your escape route, for want of a better word, from the Irish regime? The first jurisdictional threshold is you've got to demonstrate that you're one of the three things on there on the slide. So it's a jurisdictional hurdle first and foremost. Are you domiciled in England or Wales? Is it the place that you live in on a day-to-day basis? Are you in England and Wales on the day you present your petition? I forget the name of the person it was. There was a famous celebrity who literally flew in, made herself bankrupt, and flew back out again. And I'm afraid to say a lot of the German cases which go through the English courts, there's numerous ones where they literally went out the same day and somehow wondered why they couldn't get away with it. But you know, or you've got a place of residence or carry on business in England and Wales. That's just to say that's your jurisdictional hurdle. The bigger hurdle is your COBE hurdle, which I think most people will be familiar. What's your centre of main interests? And you know, as I say, if you get it right, if your centre of main interest is in England and Wales, then that will be the main proceedings, and that will then drive everything through. So you've presented your petition. If you're a foreign debtor, there was a time where the English courts were less used to foreign debtors presenting petitions, and you almost snuck under the radar, some people, in terms of doing it without actually noticing. The High Court in London has seen numerous cases, either because the petition has been presented there or because there have been challenges and the bankruptcies have been overturned. And that's developed a practice, certainly in the High Court anyway, that if there are any doubts whatsoever in relation to centre of main interests and where that debtor may come from, the English court will adjourn. You've got to remember that if you're presenting your own petition, you present your own petition and you're the only person in the room with the judge. The court is now in England has started to develop this process whereby they say, right, I've got doubts. I think that creditors ought to be given an opportunity to at least be heard if they want to. And so they have been making the debtor serve notice on all of their creditors that a bankruptcy petition has been presented. So a creditor, once they've got that process, has got one of two options. They can either challenge the centre of main interest and oppose the petition. I mean, historically, what's been happening before they adopted this practice was the first that the bank or the main creditors heard of all of this was the bankruptcy order had already been made. And so what the creditors were doing there was trying to what's called annul the bankruptcy, reverse the bankruptcy in England and Wales on the basis that the order should never have been made. And they were saying, because your centre of main interest is in England, it's Ireland, Germany, wherever. But now with this practice being developed, it's giving the banks an opportunity to say, no, I'm not, I want to challenge that. And there was a recent decision in Fergal O'Mahony in England and Wales. It was a contested petition, 2 or 3 days in England, and the bank resisted it quite heavily. And if I may, I think Fergal O'Mahony's stroke of luck, really, I'm afraid to say, was his divorce from his wife. Because he was in England and Wales, and he was coming back to Ireland quite regularly, but he was genuinely separated from his wife. He was divorced from her. And he was coming back to Ireland fairly regularly, it had to be said. There were numbers in terms of how many days he spent in England and Wales compared to Ireland. But every time he came to Ireland, he stayed at his mother's property, he came over to see his children, and so forth. And so the domicile test, that, where does he live? The judge, the registrar in that case, was very adamant that, his domicile was England and Wales. And increasingly banks and creditors aren't challenging the COMI, but what they're actually doing is getting a trustee in bankruptcy appointed, because the creditors can vote for a private sector trustee. And they're very often using that process to get somebody in and make sure that they're given a bit of a hard time and make sure that somebody's looking at them, trying to look at. And I know it's difficult because when you're looking back at things, they all put either statement of affairs in, and they changed over time as they kept over more and more funding. So looking at all of that, trying to work out what's changed, what's missing, where's everything gone, see if anything's hidden, try and trace things around. And so a lot of people are putting more effort into that process rather than an outright challenge on COMI. I'd just like to try and flag up in the last couple of slides just a couple of things that come up from COMI and how the English courts sort of view it. So the English courts look at COMI the following ways. Firstly, where, if you're a professional debtor, where do you mainly carry out your work? So there was, for example, a German notary who practiced in Germany. And there was some doubts as to whether or not, and he made himself bankrupt in England, and there was some doubts as to whether he was still practicing in Germany or not. And the courts determined on that basis that the country in which he was practicing his debt was where his COMI was, and that's why he was unsuccessful in his bankruptcy. It actually was an annulment. So you've got to look at where he carries on the work. So if you're Irish debtor and you go to the UK, then you've got to, not be practicing, not professionally practicing over in Ireland. The same with trades, looking at where you work and things like that. So you've got to try and make sure that the trade is in the right country. And I think the big thing that people probably find the hardest is that they think, well, actually, I'll go to England and I'll live in England and Wales and I'll carry on doing what I do and I'll flip backwards. I'll live there, my wife will live over here, and I'll flip backwards and forwards as I need to. And the court is really about, the courts in England and Wales certainly are looking at habitual residence. And that's a quote from a decision in where there was an annulment. And it is about where the debtor's settled home is, where his family live, where you go back to. That's really, and that's the key aspect. You've absolutely got to demonstrate that that's where you are. And there's got to be a degree of permanence to it. You can't just, most of these cases, the ones that Fergal O'Malley, for example, he was in England and Wales for about 18 months before presenting his petition. And you've got to have that permanence. You can't just sort of come in, do it for 3 months, make yourself bankrupt and go away with it. If you meet those criteria, subject to what I'll come on to in a second, the second sort of part of the test, you're looking at getting main proceedings. But as I say, you can relocate your comey, so there's nothing to stop you for once you've been made bankrupt, discharged, and coming back and moving your comey back again. It's all possible. But the key test, really, and I think this is where the O'Donnells probably fell down the most, was that you've got to demonstrate that your relocation of your centre of main interest is actually ascertainable by third parties. Has there been some form of notification process? Do they actually know, where would they associate you being there? And, if you can show notification to creditors, then you can go a long way to get yourself through all the jurisdictional hurdles. And the quote there about the Quinn case is really, it's very straightforward. The creditors mustn't have to go through a telephone directory of every jurisdiction to work out where you are. You've got to have a good idea, and reasonably ascertainable. And it's important that the habitual residence is a very much a subjective test, whereas the ascertainable by third parties is very objective. What do third parties think of? And that's me. Unless anyone's got any questions.
Very good. Thanks very much, Alan. Thank you.